Okay. Here we are, Francesco. We're live. We're here to talk about the conference that took place in Siena. So I was lucky enough to see you and Monica last week in Rome. We were hoping to cross paths again yesterday.
Yes.
Monica was able to give her presentation. It was the first ever national conference on Jure Sanguinis, and there were attorneys from all over the country. There were several lawmakers there. There was constitutional law experts. Yeah, so it was a really incredible crowd. So what were some of your real takeaways from some of the speakers or some of the things that occurred there?
Okay. First of all, thank you, Dominic, so much for helping me organize this live stream and to help summarize and recap what happened for our English speaker friends who are following us. I think that this Congress was very interesting because there were many interesting takeaways. Everyone was more or less on the same page, more or less from different points of views, giving their insights on this new scenario that we have in front of us, which is the decree, obviously, and other important issues such as the minor issue. First of all, I would like to say that this Congress was organized by the association Nati Italiani together with the University of Siena. Nati Italiani has basically the majority of the speakers were members also of Nati Italiani, which is an association that spreads the values and the principles of Italianness, let's say, abroad. So they are all very involved in these developments in all things Italian citizenship. So to begin with, what should we start with? Because there were really many topics. Should we immediately tackle the minor issue, which was
I think that is the top of, I think there's two major issues on the top of mind and everybody knows what they are. So absolutely, please.
Excellent. So the two members who dealt with the minor issue mainly were Mellone and Attorney Restanio from our firm. Attorney Mellone and Attorney Restanio. First of all, just to explain for those who perhaps do not have it clear yet, the minor issue is an interpretation of the law. The minor issue is born from the interpretation of two articles, which are Article 7 and Article 12 of the law of 1912, which for hundreds, literally more than 100 years, were always interpreted as meaning that when the parent naturalized and the son of that parent was a minor, the minor did not lose the citizenship, the Italian citizenship, obviously. This was an Italian law. What happened was that recently there were some rulings by the Cassazione, which is the Italian Supreme Court, which has the role of ensuring that the law is interpreted. Exactly. The correct interpretation and application of the law. So they basically established that the classical interpretation was reversed. They basically reverted this interpretation, and basically now it takes prevalence the article that says that basically the minor loses the citizenship when the parent naturalizes. So this has cascaded into a series of events, which the main one is the circolare by the Foreign Ministry that basically makes it now impossible to be recognized in this scenario. So there are workarounds, as we know, in this situation, which is extremely weird and has given birth to many weird cases, such as a brother, which is also your case, Dominic, which we discussed,
yes.
where a brother was recognized and the other was not, simply because of the fact that one started the proceeding before these rulings and the other started it afterwards. So this is being discussed right now. This is something that is now before the Supreme Court, also in many different cases. So let's start just with the order of the speakers. Avvocato Mellone talked first. Mellone has right now a proceeding which is pending before the Sezioni Unite of the Cassazione of the Supreme Court. So he remarked that he has this important proceeding in front of himself, and basically he wanted to stress the fact that this ruling before the Sezioni Unite will also be connected in some way to the decree, to the Tajani decree.
Yes, and that caught my attention a little bit because I hadn't heard of these coming together. And in the April case, he boxed this quite a bit with the judges, but this is the first time I've heard him say these issues are coming together at the cassation, because we know one's at the cassation and the other is at the constitutional court level right now. So sorry, please continue. Yeah, that was
Exactly.
very interesting.
Basically, what Mellone said is that according to him, he hopes that the Supreme Court will establish some sort of principle that will apply in general. So something that talks about the importance of the will of the person who loses the citizenship.
Mm-hmm.
Because one principle, and this he remarked that this will be the first time the Sezione Unita deals with citizenship, Jure Sanguinis, after the great naturalization case of Brazil,
Yeah.
which was the last very, very important one. And by the way, all cases by the Sezione Unite are very important in the case law that we as attorneys apply. So basically, all of these situations that end up before the Supreme Court, the way they are defined are then later relevant for other cases.
But maybe I can just do a little bit to help, because it took me a long time to understand this. But when the Cassation Court does a unified section, it acts very much then like the United States Supreme Court. That decision carries precedent. Whereas when it's just an individual judge, and this is very different than how the United States Supreme Court works, an individual judge can hear a case, and that case does not necessarily carry nearly as much precedent for the rest of the judges in the country. But when you talk about the United section, that's a big deal because that becomes jurisprudence. That becomes the rules.
All the cases that what you say is exactly correct, and all the cases that established the minor issue as the right now de facto dominant interpretation were not by sezioni unite. They were single sections, sezioni singole of the Cassazione. So it's not that they establish it's not that they are not as important, but they have an importance of reputation and strength, let's say. So the minor issue, what Mellone, the idea again that I was summarizing that Mellone brought forward is that the important thing that he wants the Supreme Court to pronounce on is the importance of the will of the person who loses the citizenship. Because he hopes, and this is something, in fact, that the court has said in other occasions, such as the great naturalization case. According to Mellone, the court should say something about why it's so serious that a person should not lose their citizenship if they do not do a voluntary act in that sense, if they do not have a voluntary behavior in that sense. So he hopes
explicitly, they must explicitly say, I do not want this thing.
Exactly. So he hopes to take out from the hopefully positive results we might obtain before the Sezione Unite this principle that could be applied to the decree as well.
Something I was speaking about with Marco yesterday was, and he estimated that between 60 and 70% of the naturalizations of the men in the United States naturalized at about 50 or 60%. And I completely agree with that from my experience. So that essentially means the minor issue, not quite, but is a problem for about that many people, 60 or 70% of the Italian Americans right now, or the Italian Brazilians, or the Italian Argentinians, whomever it happens to be.
Yes, absolutely. We also see that in our day-to-day cases. I mean, it's more or less that the percentage. One American client over two has this issue. It's absolutely true. Then again, the Restanio attorney intervened in the conference, and she had some news. She had some news that she wanted to share in this wonderful occasion, and the news were that we also were joined in this Sezione Unite case.
This is the extension of the April 1 case, correct?
Exactly.
Cake by the ocean, that is the answer to your question that I wasn't sure if I could talk about yet. So thank you for sharing that.
Yes, absolutely. Right now it's in the open, let's say. This followed our case in April 1st, and after this case, it was suspended. It was suspended because Mellone case of the 27th of May, if I'm not mistaken, were referred from the normal section of the Cassazione to the Sezione Unite. So that referral, since it's more or less the same topic, it's exactly the same issue, the minor issue, impacted our case, which was suspended, because being similar was the usual practice of tribunals when a higher court, or in this case, a higher formation of the same court, is deciding the same topic, is to suspend. But following this, what the attorney focused really hard on was arguing that our case should also be brought forward before the sezione unite. So we presented a request in this sense in September 18th, which was accepted. And the court agreed with us, and they accepted that we also should be put in the position of bringing forward our, in this case, her important arguments before the sezione unite, because obviously the sezione unite ruling will impact the other ongoing cases, such as ours. And if our case was suspended, meanwhile the sezione unite decided, then de facto we didn't have a defense because we couldn't argue for our case, obviously, or the case of our clients, obviously.
Yes, of course.
What the attorney really focused on was trying to explain, first of all, the origin of the minor issue, which I tried to anticipate before, which is basically based on a misconception, on misguided initial case law, let's say, that had to do with a completely different case, which was a case of a Lebanese adopted minor, who lost the citizenship due to the naturalization of the father, but not because he was born Italian, because he acquired the Italian citizenship when he was adopted by this Italian individual. You understand?
So there's nothing Jure Sanguinis to this.
There's nothing Jure Sanguinis to this, and it's a different article that would have applied in that case, not Article 7 and 12. You understand? Yeah. So in that precedent, Cassazione said this article applies, and then we don't know why the following rulings took on that precedent and continue saying this article prevails on the other in different scenarios, though. So this is what she really wanted to stress, and she tried to explain in the conference. Also, as I already also anticipated, according to her, the correct interpretation is the interpretation that makes, let's get more specific, Article 7 more important than Article 12. I'm talking always about law of 1912, 555 of 1912. And basically, according to the thesis of our attorney, why shouldn't the minor lose the citizenship? Because the purpose of Article 7 was to protect the minor who was already born in a situation where he has an Italian household and lives in a foreign state.
Now, is this for Jure Solis matters, correct?
Exactly.
Okay, and just to be clear, the United States is a juris solis country, because anybody born within the boundaries of the United States automatically acquires citizenship.
Exactly. The case was that exactly how many parents naturalize in the United States, it's also true that many children were born in the United States. So if this interpretation is accepted, which was, by the way, the interpretation that was peaceful for 100 years, as I said.
Very, very firmly established case.
Exactly. The child was, since he was born, both American by soil and Italian by birth. And the article said specifically that these individuals should not lose the citizenship when the parent naturalized.
Isn't there a word somewhere that's been argued in the word acquired, specifically around the American or the Jure Solis citizenship, because one cannot acquire necessarily something they're born with? Yes. This was an argument that is also brought forward mainly by Meloni, if I'm not mistaken, that he argues that acquired means only voluntarily. Something you have to take, not something just exists for the fact of your birth. Yes. So basically the minor issue was, more or less it was what was discussed about the minor issue. It's just, let's say, a preamble of what will be really, really discussed before the sezione unite. Just a little picture, a little glimpse into how the attorneys' minds are building their argument. Now, I believe that this is not on the calendar yet. This is a very important case to everybody. It's not yet. Is it possible to predict winter, spring, or? Optimistically, before the end of this year. 2025, okay. Or as far as February. Or beginnings of next year, perhaps, I would say it's possible before the end of this year. Okay. Now, we heard a lot about that. How about the emergency decree law? Yes. What's happening there and what was discussed? I know I'm looking at my notes over here on my other screen, and there were a professor and a lawyer, Urbani and Dami, were discussing how not just the law itself, but the conversion from an emergency decree into law, was it actually emergency? This may have violated several key articles in the Italian constitution, and we haven't even gone up to European law yet, which sits above Italian.
Yeah, yes. Basically, the new decree was emitted via decreto legge. The decreto legge is a very specific type of legislation here in Italy, which can be issued when there is a situation of emergency. De facto, what many this perhaps is not cited as much in these discussions about citizenship, but it's important to say that the decreto legge is widely used for situations that have no character of emergency at all. Exactly. Because it is a much more expeditious way to draft a law. And in this case, with a law designed to take by surprise people, it's the perfect tool, let's say. Then the decree needs to be converted by the parliament, which it was. And if it's not converted by the parliament, it falls retroactively, but it was not the case. The main concern about this type of act that was passed by the government is that it shouldn't be considered an emergency situation, and the citizenship is such an important matter that it should be left to the ordinary law.
It deserves the full debate, the full democratic, the full legislative process, because it is a bedrock, foundational issue of Italy since the diaspora began.
Exactly. So it would have really been worth to have the ordinary legislative process with discussions with Exactly. But this was not the case. Obviously, then now we have to consider the fact that the decree has been brought forward before the Constitutional Court. Currently, it's pending. It's the Torino ordinance from this year. And the attorneys involved that I remember are Bonato and Restanio, the attorney of our firm. There are others. I am forgetting right now, but there are others very important. So what the Constitutional Court does is checks the compatibility of a law, any type of law, in this case a decreto legge, with the Constitution. So it doesn't deal with a specific case. It says this law works for us. I mean, it's legitimate. It is constitutional, or it isn't. So if the Constitutional Court will say that this decree is more specifically, let's get more specific. What is the aspect of the decree that was brought forward before the Constitutional Court? The retroactivity. That is the main problem. There are many constitutional reasonings, let's say, of why the decree might be unconstitutional because of its retroactivity. First of all, the principle of legitimate confidence in the law, the legitimate trust in the law.
That the law is stable and predictable.
Exactly. This should mean that if a person, if a law has been applied in the same way for 100 years, and a person gets caught by surprise, there were many examples during the conference, very, very interesting, of, let's say, a person who had a child 5 days before the decree, how that person would go before the concert and register. Exactly. Because the child was basically, his citizenship was revoked without the possibility for them to do anything at all. As for many people, it's not less just than someone who never started the proceeding. So this is one of the reasonings. The other reasoning is the Article 3 of the Constitution, which is the principle of equality in Italy. Why is this distinction so arbitrary, retroactive? I mean, if a person is Italian, that person is Italian. It's not the fact that he was recognized or not, because it's a right that has already been a part of that individual's juridical sphere. You understand? So the distinction is purely arbitrary on what is called an irragionevole element. So an element without reasonableness, which is the moment of when someone applied for the recognition process, which has no correlation to the fact that he feels more or less Italian, or he has a connection of some type, or he doesn't have, with Italy. You understand? So this is also the very important.
Are you Italian enough? Becomes the question.
Exactly. And these and others. I mean, I'm being very reductionist here. There are way more arguments that were brought forward and were discussed.
This is going to be a thing. There's multiple angles by which this is going to be attacked over time.
Yeah.
So there's a couple of questions here, and I think the second question we'll talk to is from Jake Smith, and he says, does Italian law have the idea of severability, the ability to cut off If part of the decree falls, does the entire law get struck down? And I'm going to start on this one for just a second because Maloney talked specifically about
Yeah.
this. He talked about how the court can behave like a surgeon and it can go in and say, these are the parts of the law these are the specific parts of the law that are unconstitutional. Now, please help me, and I'm no expert. You're the
Yeah.
attorney in Italy. The Constitutional Court can either say remove these parts of the law. They could potentially do it themselves. They could send the whole law back and say rework it. So, just how does that behave within the Italian legal system, within the Constitutional Court? And then we've got another question about the Cassation Court after that.
Okay, I will try to put it very simply. The Constitutional Court the Constitutional Court ruling is a very fluid type of proceeding, but has very rigid premises. What do I mean? I mean that to bring something before the courts, the Constitutional Court, you have to specify the specific article of the law that you bring forward, the specific aspect of why you believe it's unconstitutional, and the specific article of the Constitution that you believe it is in contrast with. So having said this, I have said this and basically explained nothing, because the article of the decree is so convoluted and complicated that you can say this article is unconstitutional, but you understand that the court can make different considerations. But to answer the question, the specific question is the retroactivity of this decree constitutional? The court could say a total yes. So it could say, it could simply cut down the decree in the part that is retroactive. So the decree would stand for the future, for the people that were born after the decree. So those criteria would apply to everyone who was born after the decree. But it could say, yes, it's, I don't remember if I said no, yes before, but it could say it's constitutional. So it could say this stands as it is, which is hopefully unlikely, but it can also, in fact, take a middle ground decision. The Constitutional Court, especially in very complicated cases, such as the very cases that sparked a lot of discussion in Italy, such as the euthanasia cases, the court can sometimes not only carve out a part of the law, more specific than the question that it is posed, but it can also say it is unconstitutional in the measure that it does not include something.
Additive or subtractive.
Exactly. So these type of decisions are called manipulative decisions of the law. So it works. This is usually done when the court has no other solution, because it's not the job of the court to make up laws. But in the case, for example, of euthanasia, the Constitutional Court had said, if I'm not mistaken, 2 or 3 times that this had to be dealt with by the legislator, who never did. And so to not leave the constitutional law as it was, it just basically wrote a new law for euthanasia in Italy.
Being extreme, correct? Because
Exactly.
I mean, doesn't the Constitutional Court much prefer that the legislature be the legislature?
Exactly.
And check and balance them.
Exactly. So yes. So there exists the possibility that the Constitutional Court says, yes, the decree is unconstitutional in its retroactivity, so it stands, but not for cases before the decree. So basically not for everyone, but only until a certain time. That is a possible scenario, absolutely. There could be a window in which people would have to apply very quickly in order not to be a subject to the decree, you understand?
I've heard several people suggest that might be the middle ground, that's saying, okay, you have X months, be it 12, 24 months, etc. And I have a lot of hypothetical questions about that are just hypothetical. So let's not get into those. If I do most of my work in the United States, if this window is 12 months and you have multiple generations of people in Cook County, New York City, or New York State, you're getting very tight right now on that.
Yes.
So keep that in mind.
No, I wanted to quickly tie it to what you were saying, that this was interestingly discussed in the conference, and Bonato in particular said that the judges with which he discussed very recently were all in agreement that the citizenship law needed a new reform. I mean, it needed to be changed somehow. Modernized. But what they did not agree on was the method in which to do this. And the government even considered having, this was said by Taddone, said the government even considered putting a time limit, let's say, on the old rules, on the rules that we were used to. And it also considered just to leave the decree for the future. But in the end, they decided to do this, which is Terrible.
The next question I have is, what is the composition in terms of political leaning of the United Section of the Cassation Court?
Yes. Yes. Basically, the Cassation Court are all members of the Magistratura, which in Italy is a class of that includes both judges and prosecutors, what you call prosecutors in America. You can only do one, obviously. You can be either a judge or a prosecutor. But all these positions are reached via public concorso, so public tests. So they're not like the Supreme Court in America, appointed by politicians. They reach that stage because they are judges with a judge career behind their backs. So it's not what is instead chosen by the parliament together with the president of the republic and the CSM, which is the council of the judges, is the constitutional court. So the Supreme Courts are all, we can say, neutral members because they are all there because they passed a public exam. Meanwhile, the constitutional court, there you could talk about appointed by left wing, appointed by right wing, but it's never really political leaning, the constitutional court. I wouldn't say it's politics plays such a huge role in these type of judgments as they do in the United States.
Yes. And of course, every judge has personal feelings of where they live, and they're going to use those personal experiences, apply it to the law, etc.
Obviously, judges should be third and impartial. Obviously, each judge has its own view of the situation.
Yes, absolutely.
Yes.
What should prior administrative applications do? Submit a court case now or after the hearing? I don't know if there's enough information there without the detail to really understand it. Is there a 1948 path?
Yeah.
Is there other things you could do?
The hearing of the minor issue.
I assume that to be the case. Section.
Or the United Section. Well, if someone has an administrative proceeding pending, the best, first of all, as a lawyer, not because we are attorneys, but because I seriously think this is the correct advice, is to check the individual situation with a lawyer.
Yeah.
With an attorney, with someone. In general, what we are seeing is that administrative proceedings end either with a rejection for the minor issue, but if that rejection has not yet reached this person, then right now some consulates are suspending this type of cases. But then again, you should explore what are the best ways to inquire about this, about if the case is suspended or not. Yeah.
And there's so many different cases. There's so many scenarios in there.
Exactly. I mean,
you need to know so many details. So I will put in the notes your contact information, my contact information, some things like that.
Yeah.
We just had one more question pop in. I've heard this one before. There have been some rumors that there is a change to Jure matrimony.
I honestly have not heard this. I think perhaps it is likely that there are, but right now it's just speculation.
I don't know if this is 14th. Yeah, there's another bill out there that I think that hasn't moved in quite a long time that this was a part of.
There are many laws that are currently being worked on, and this is why we always recommend to move quickly. Because this was also said by Melone very rightly, that there is no way, if the Constitutional Court declares the decree unconstitutional in its retroactivity or in other parts, then there is no way to avoid a new law in that case. And all these rulings will only, in my opinion, give the legislator more ideas on how to create problems and blocks, etc.
So if I'm hearing you right, before any of this happens, so since how the Italian system works is if you apply your case, if you file your case today, you're going to be evaluated on today's laws. If the retroactivity is knocked down, that's a good thing for you. And if then there's some additional legislative mischief, shenanigans, you would be protected from that. So the best advice I've been giving people is filing a case, especially if you've got the minor issue or a Tajani problem. If you've got a clean case, it's an entirely different story. But what you're buying is insurance for preserving the greatest number of options going forward. So if this is incredibly important, you're buying insurance that you're any option that becomes available, you'll be able to participate in.
Yes.
And then, well, we had one more question. I think this one again depends. For people on the wait list, is there advice for continuing or a judicial approach? This is so dependent upon your case. I think it's impossible to give a fair answer to that question without knowing a lot more specifics.
I didn't catch the question. What is the question?
For people that are on the wait list, should they wait or should they file a case? And that so much is dependent upon the specifics of your case.
Yeah.
It's just not possible to give a fair answer to that.
Yes.
If you need help in Italy, Restanio Law can help you in Italian, English, Spanish, all equally as competently. You're easy to get a hold of. You can be found on LinkedIn. You can be found on your website. And I handle everything on the American side. So anybody needs documents, amendments, corrections, etc. And then, of course, you've got a seamless communication between both myself and whomever on the Restanio team is taking your case. So anything you'd like to sign off with before we say well, good afternoon in the United States, but good evening here in Italy?
Yes, I wouldn't say. I would say just that these are very complicated times. And I think that hopefully we will get some help from judges, because many of the changes that were done are not only unfair, but really unjust, because they, in my opinion, really are against the most important principles that we have. I would have an attitude of careful optimism, cautious optimism. That is the expression.
And,
Yes.
and then even after all of this, particularly around the decree, we haven't even begun to discuss EU law. So there's a whole nother level of strategy happening there. So with that, this has been a great first live stream we've done together, and keep your eye out. We'll do some more.
Thank you very much, Dominic. Thank you. Bye.